Hello, welcome to this presentation on the module on theft of intellectual property. My name is Shovik Kumar Guha and I'm an assistant professor at the West Bengal National University of Juridical Sciences, Kolkata. So today we will be learning about how intellectual property can be subjected to theft and infringement. The learning outcome for this module is to make the learners understand the fundamental concept of intellectual property and its various categories, to make the learners understand the ways in which intellectual property rights are vulnerable to theft or infringement, to acquaint the learners with the existing Indian laws dealing with intellectual property theft, to make the learners understand the process in which actions can be taken to both prevent such theft as well as to initiate legal proceedings against them. As far as the introduction is concerned, we'll start with the concept of intellectual property. Intellectual property refers to any creation that one's mind may come up with. It includes inventions, literary or artistic works, and even certain names, symbols, or images that one may use in relation to commerce. Such properties, broadly speaking, can be subdivided into two categories: industrial property on the one hand and copyright on the other. Now, industrial property itself consists of property such as patents that one can have for inventions, such as patent over a new medicinal product that cures a certain disease like diabetes, say, trademarks that one may use to distinguish one's products or services from those of competitors in the industry, such as the mark Icon used in association with all the containers manufactured by a certain company, designs that are used for manufacturing various kinds of products, such as the design for a newly conceived automobile engine that uses fuel more efficiently than its counterparts. Then we can have geographical indications that are used to differentiate between products or services originating from different regions and containing specific characteristics owing to such origin. For example, we have the Darjeeling tea. Copyright, that's the second category, on the other hand, is accorded over literary works like books, poetry and dramatic scripts, movies, music records, creations of art such as paintings, photographs, etc., and architectural designs. It also includes within its ambit rights of performing artists over recording of their performances, rights of producers over phonograms of their recordings, and rights of broadcasters over programs broadcast over television and radio. As has been recognized by global conventions and treaties such as the Paris Convention for the Protection of Industrial Property, the Berne Convention for the Protection of Literary and Artistic Works, and the trade-related aspects of intellectual property rights, or TRIPS, according protection to such intellectual property is of the utmost importance and significance, for it seeks to maintain a delicate balance between the incentivizing the creators of such property and public interest in having access to new inventions and creations and other valuable products of the mind. That is why it is also necessary to ensure that lawfully recognized rights over such property is not violated or infringed upon, the latter being what the theft of intellectual property intends to aim for. Now, theft or infringement of intellectual property, what does it mean? The theft or infringement of intellectual property signifies theft of any material that is protected by copyright and or subsequent publication of the same in an unauthorized manner, or say of closely guarded trade secrets, including sensitive information from industries, or say violation of trademark of someone else by way of passing off or counterfeiting one's goods as those of another, or manufacturing or selling products protected by patents and similar activities. Especially in the commercial world, such theft or infringement may have a devastating impact on the victim's business by making it lose its competitive edge. When it comes to Indian laws on theft and infringement of intellectual property, let us see what some of these laws are. Some of the prominent Indian legislations that are applicable to according protection to different forms of intellectual property and prohibiting theft or infringement of the same include the Trademarks Act 1999, the Copyright Act 1957, the Patent Act 1970, the Designs Act 2000, the Geographical Indications of Goods Registration and Protection Act 1999, the Semiconductor Integrated Circuits Layout Design Act 2000, the Protection of Plants, Varieties and Farmers' Rights Act 2001, and the Biological Diversity Act 2002. Now, each of these legislations have their own provisions in relation to infringement of the intellectual property protected by them. Take, for instance, Section 29 of the Trademarks Act. That requires the allegedly infringing mark to be either identical or deceptively similar to the registered trademark. The goods or services using the infringing mark should be covered by the registration of the registered mark, and the infringing mark must be used in the course of trade and in a manner such that the use is likely to be taken as being used as a trademark. Now, the infringing mark should be likely to cause confusion on the part of the public or likely to have an association with the registered mark. For instance, Company A uses the registered mark ICON for umbrellas which are manufactured by it, and Company B seeks to infringe the same by selling umbrellas marked ICON. It's just that the letters of ICON are in small case. Furthermore, if the goods or service using the infringing mark is not similar to those using the registered mark, even then it can be considered infringement if the registered mark has acquired reputation of which the infringing mark seeks to take undue advantage. Apart from this, the proprietor of the registered mark or his legal heirs or assignee can also bring action for infringement if a person seeks to use the mark as a trade name or part thereof for dealing in same goods or service, or to use the mark in advertising, taking unfair advantage or being contrary to the honest practice in industrial or commercial matters, so that the reputation or distinctive character of the registered mark is being harmed. Even if the original mark has not been registered, a passing off suit can still be brought by its user against anybody who seeks to exploit the goodwill acquired by the mark. Similarly, we can have Section 51 of the Copyright Act, which addresses infringement as any activity by any person without an appropriate license to do anything that the owner of the copyright has an exclusive right to do, such as right to reproduce, right to publish, right to modify, right to translate, etc., etc., subject to the statutory exceptions such as fair use as prescribed under Section 52 of the Copyright Act. Again, we can have Section 48 of the Patents Act, which identifies as instances of infringement of product patents the making, using, offering for sale, selling or importing of the product in India without the patentee's permission, where infringement of process patents consists of similar activities in relation to a product obtained directly by that process in India without the permission of the patentee concerned. Considering the actions under consideration are being referred to as theft, questions may arise regarding the applicability of the Indian Penal Code to them. Now, Section 378 of the Indian Penal Code defines theft as follows. Whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. Section 22 of the IPC defines movable property as intended to include corporeal property of every description except land and things attached to the earth or permanently fastened to anything which is attached to the earth. Therefore, we can see that so long as any intellectual property remains merely intangible in nature, it cannot be subject to theft as it stands under the Indian Penal Code. Therefore, data or idea itself cannot be stolen, but if a computer disk containing information such as trade secret or a paper on which the same is written down is used in an unauthorized manner, the property under consideration becomes corporeal and hence vulnerable to theft under the code. One may also refer to the Supreme Court's decision in Avtar Singh versus State of Punjab, wherein electricity was held not a movable property and hence not normally covered under the definition of theft under the Indian Penal Code. Having said that, in that case, Section 39 of the Electricity Act specifically extends the applicability of Section 378 of the Indian Penal Code to apply to electricity. Therefore, we can see that for intellectual property like patents, copyright and trademark to come within the ambit of this section, the concerned legislations which cover them ought to have a provision similar to Section 39 of the Electricity Act. Now, the next question is what to do when you are facing intellectual property theft or infringement. The very first step towards addressing the concern of theft of intellectual property is to identify which kind of intellectual property one is dealing with. It is only then that one would be able to determine what sort of rights the concerned owner of such property has or does not have. For the purpose of identifying these rights, one needs to seek recourse to the legislations that govern that specific kind of intellectual property, such as the Patents Act for patents, the Copyright Act for copyright, or the Trademarks Act for trademarks. In India, there is no specific legislation created by individual states to govern intellectual property rights within their own jurisdiction. Therefore, only the central legislations, as we have mentioned before, are concerned with the same. While certain categories of intellectual property need not be compulsorily registered so as to be accorded protection over, such as copyright, still others need to be registered before one can allege infringement of the same, such as trademark or patent. Now, once the owner has determined the exact nature of the rights that he has with respect to the property concerned, the next step for us is to document the theft or infringement of the property that has allegedly taken place. Now, in order to do this, it needs to be identified first who had access to the property in question. If it is an industrial property like a patent for an invention, the owner of the patent would have to reveal all relevant details of how to manufacture the invention at the time he is being granted the patent protection. Therefore, it is obvious that any person can use that information to manufacture the invention on his own. However, if such invention is being manufactured and sold for profit without prior consent of the patent owner in the form of a license and without paying to such owner the necessary license fee, then that is what constitutes theft or infringement of the patent. If the property is like, say, a copyright or a trademark, it is also available to the public at large, especially if the display or the publication of the concerned property has taken place in the electronic media or the internet. In such case, one can only identify the alleged thief or infringer once that particular thief or infringer begins to sell, use or exhibit the stolen property out in the open. Now, if it is a trade secret, on the other hand, it becomes easier to identify the limited number of people or organizations who have had access to it. Once the alleged infringer has been identified, the owner should document every instance of the theft or unauthorized usage of his property by such infringer. If the use is taking place over the internet or similar electronic media, then screenshots of such usage can be taken. If the product having patent protection or the work having copyright protection is being sold in an unauthorized manner, then samples of the same can be collected. While collecting and documenting such evidence, the dates of collection ought to be mentioned specifically and with care for subsequent evidentiary purposes. If the infringed material is being displayed on a website or say even in any physical brick and mortar address, the owner of that particular property should procure details about the owner of such website or establishment in whose name the domain or shop may be registered. Then he should also note down the relevant IP address or physical address, the contact number. Not every kind of use, even if unauthorized, may not consist of theft or infringement of intellectual property. One should be very careful about that, especially in matters involving copyright. Say, for example, there is the concept of the fair use exception. One of the indicators is if such use is for commercial purposes or for educational, non-profit purposes. Another indicator is whether the use has been to create parody or a satirical version of the original creation. Now, the amount of the original creation that has been reproduced is also another indicator. For example, quoting a paragraph out of an essay while acknowledging it to be the work of the original author may not comprise infringement, but copying a whole chapter from a book may be treated as infringement. if the impact of the usage deprives the original owner of the intellectual property of his expected returns or income from the target market, then such usage is less likely to be allowed as fair use. These factors need to be taken into consideration before one pursues any legal remedy against a perceived infringement. Another important step is to obtain a reasonable estimate of the amount of loss that has been suffered by the owner of the intellectual property, whether directly or otherwise, resulting from such infringement or theft. While ascertaining the amount of exact loss suffered is not a conditional prerequisite for establishing infringement of the concerned intellectual property, and mere proof of unauthorized usage is usually deemed to be sufficient, still, such estimates may be necessary if the owner is also seeking to recover damages or compensation from the infringer. Such loss may be monetary or otherwise, such as reputational, and may even include potential loss such as lost sales, etc. Once these steps have been taken, the owner may choose to send a cease and desist notice to the alleged infringer, citing his own claim over the intellectual property in question and asking the infringer to stop such unauthorized usage. If the infringer refuses to do so, then this can be considered as an additional evidence that such usage was not unintentional but deliberate in nature. If the infringer fails to respond to the notice or ignores or refuses to abide by the notice, then it is time for the owner of the intellectual property to initiate legal proceedings against him. There is no doubt that the Indian regime of according protection to intellectual property, be it from the perspective of the legislature, the executive, or the judiciary, is a fairly well-developed one. Even the erstwhile delays involved in judicial proceedings that had at times rendered enforcement of rights related to such property a difficult exercise, has in the present times been reduced considerably, owing to judicial enthusiasm and efficiency. While the courts have readily granted relief, such as injunction, awarding punitive damages or monetary damages for infringement of such rights is still not a very common occurrence. Any government authority, including police and other law enforcement agencies, can be ordered by the judiciary to carry out any directives that it may pass to ensure prevention and prosecution of such theft or infringement, such as, for example, John Doe orders, which can be passed even without the alleged thief or infringer having been identified. In case of non-compliance of such orders, the courts can initiate contempt proceedings or issue sanctions including fine or imprisonment. In case a civil suit has been filed by the owner of intellectual property against infringement, he can claim several kinds of relief such as permanent injunction preventing continuing unauthorized usage, interim injunction pending final decision in the suit, damages or compensation, seeking accounts from the infringer of all the profits that he might have gained out of such usage and directing him to hand over any profits to the original owner. There is also the possibility of getting Anton Peeler orders appointing local commissioner to take custody of infringing material and occasionally even destroying all infringing goods or related material. The next question to address is, can criminal proceedings be initiated? Now, if the infringement is in relation to trademark, copyright, geographical indication, plant variety, semiconductors, integrated circuitry or design layouts, the aggrieved owner can initiate criminal action too by registering an FIR, a first information report, or by filing a criminal complaint before a competent magistrate court. He can also apply to the court to issue warrants for search and seizure and order the police to raid the premises where infringement might be taking place, as well as arrest the people involved. As is the case of John Doe orders, such a criminal case can be filed even against persons whose identities are not known, and both these civil and criminal proceedings can be carried on simultaneously. The next question we need to know is, where do you go Where do you approach? The lowest forum here where one can initiate legal proceedings against theft or intellectual property is the district and sessions court. Now for this, one needs to ensure that the court has the necessary territorial and pecuniary jurisdiction, which is the maximum amount of money involved in a case that the court can decide. In case there is any high court having original jurisdiction that can hear matters directly and not only as an appeal, that can be said to have territorial jurisdiction over the cause of action, that is the theft in this case. The matter can be filed there too, subject to, of course, paying the requisite court fees. Apart from this, several states in India have also formed dedicated special intellectual property cells, the primary task of which is to inquire into offences dealing with infringement and theft of intellectual property. When it comes to the other applicable laws to such infringement or theft, if anybody engages in such infringement or theft and extends the same to import or export of any goods that contribute to such infringement, then such activities can be curtailed under Section 11 of the Customs Act 1962, a provision intended to protect, among other things, patents, trademarks and copyrights. Such goods can be confiscated, and under such conditions, a customs officer has the power to inspect any premises, conveyance, x-ray any person and effect search and seizure, as well as arrest and interrogation if he believes such goods to be of contraband nature. Along the same lines, we also have the provisions of the Intellectual Property Rights Imported Goods Enforcement Rules 2007, which are also in effect. Now, these rules have been created to satisfy India's commitment to the protection of intellectual property under the provision of the trade-related aspects of intellectual property right, or TRIPS. Now, they too allow customs officials to take actions with regard to imported goods violating intellectual property rights, and such actions do not affect any other remedy that the legislation governing such goods may prescribe. When it comes to looking at cyberspace, technology and theft of intellectual property, one of the common terms used to indicate theft of especially copyrighted material such as software, music or movies is piracy, which costs the respective industries as well as the national economy huge sums of money every single year. Across many websites on the internet, pirated, unauthorized copies of such material are made available for the public on a regular basis for little or no consideration. The people or organizations that have actually invested in producing such material therefore suffer from huge loss of sales or royalties, and therefore loses incentive to remain in the business. Data theft, including sophisticated technological means such as hacking, cracking, phishing, SQL injections, identity theft, usage of viruses, malware and trojans, also regularly leads to theft of sensitive corporate information, including trade secrets. This phenomenon merely indicates that technological progress has increased the risk, scope and impact of theft of intellectual property manifold. Given that the investment required on the part of the thief or infringer in the context of cyber piracy as described above is minuscule in nature as compared to the huge returns involved, as well as lack of an international intellectual property rights regime and framework to address such activities and concerns that transcends national boundaries, it is only natural that little has been done till date by way of effectively curtailing such activities. In the light of information of the proceeds from such theft being used to finance global crimes, including terrorism, it is imperative to generate a cooperative framework on an international scale involving a combination of traditional law enforcement connected with cyberspace countermeasures that would be able to address such concerns in an efficient manner. Intellectual property being intangible in nature, especially in this age of technology, the repercussions of its theft can and do transcend geographical boundaries and involve multiple jurisdictions and rules and complicating regular investigative processes such as collective evidence. lack of cross-border regulatory cooperation is yet another barrier faced in this context. When it comes to the role of the Information Technology Act 2000 in this context, to a certain extent, protection is indeed provided by the provisions of this particular act, which can be resorted to for the purpose of intellectual property theft in cyberspace. Section 43 of this act, for example, protects against destruction and unauthorized access of the computer system, including unauthorized downloading, extraction, and copying of data, as well as unauthorized introduction of computer viruses, of contaminants. Section 65, on the other hand, prohibits any knowing or intentional concealment, destruction, alteration of computer source codes and tampering of computer source documents. Section 66 of the IT Act, on the other hand, prohibits the activity of hacking, which is an act of destroying, deleting, altering or diminishing the value of data stored in a computer with an intention to cause wrongful loss or damage to any person, or with the knowledge that wrongful loss or damage will be caused to any person. Section 70 of the IT Act prevents access or attempts to secure access to protected systems. This is protected systems is actually declared thus by the government and data stored therein. Last but not the least, Section 72 of the IT Act protects against breach of confidentiality and privacy of the data. The Act provides for punishment, including hefty fines and imprisonment for contravention of these provisions, thereby curbing to a certain extent intellectual property theft in cyberspace. Now, when it comes to the question how to protect against such theft, we have to remember that technology, while thereby compounding the problem of intellectual property theft, may also provide the means of detecting it and prohibiting it. Now, one of the best ways of protecting information, including intellectual property, is of course by limiting access to the same on a need-to-know basis. But this is applicable more to property like trade secrets than, say, material which is protected by copyright, which is usually publicly accessible. A twofold strategy of preemption as well as a robust organizational strategy of greater awareness of intellectual property security needs to be adopted therefore. This would include providing necessary training to both the employees as well as highlighting such policies in public documents of the organization, including websites regarding existing law, policies and legal consequences of a range of actions. Increased vigilance in terms of employee authentication, blacklisting certain intellectual property rights by way of IP addresses, limiting administrative connection, monitoring outbound network traffic and logs are some of the fundamental protections that can be implemented. Having periodic and regular information technology audits, testing the strength of organizational server and system may also be yet another option. Immediate organizational response to complaints and seeking appropriate enforcement options should be another measure that the concerned organization can undertake. Now, does India really provide protection against theft? Although certain reports from developed countries such as the United States of America, let us consider the Intellectual Property Index, which is published by the US Chamber of Commerce. Now, they would rank India among the very last when it comes to according protection to intellectual property. However, this should not be confused with the country's inability to counter theft of intellectual property or not having suitable legal instruments to deal with the same. While such provisions do exist in Indian legislations too, as has been mentioned above, it is a matter of national policy to restrict practices such as evergreening, which means seeking new patent protection for products after the normal duration of 20 years of protection has expired by introducing negligible incremental changes, at times merely cosmetic in nature. Now, this kind of evergreening usually happens with pharmaceutical products in particular. Mention may be made in this context of the recent Delhi High Court decision of rejecting Gilead Sciences Incorporated's patent over the drug Sovaldi or the Supreme Court's rejection of the Novartis patent on the beta crystalline form of imaginative mesylate on similar grounds. Now, this policy stance of India is rather to ensure continuing accessibility of pharmaceutical products and life-saving drugs, instead of keeping them within the ambit of monopoly for time immemorial. Therefore, to conclude, while instances of theft and infringement of intellectual property in all its forms are indeed on the rise, there can still be precautionary as well as curative actions that can be taken against such theft. And while Indian legislature and judiciary certainly have some way to go, especially when it comes to protecting attempts of theft using technology, they are nonetheless off to an acceptable start in the right direction. That will be all. Thank you.